Okay, welcome to everyone who is here with us at McMaster Innovation Park. And to those who are watching via live stream, thank you for joining us. This event is hosted by Interactive Ontario and made possible by our presenting partner, the Canada Media Fund, our event partner, RBC, and our community partners, McMaster Innovation Park and Hamilton Economic Development. And now I'd like to introduce our speaker today. Jacob LeBlanc is a senior advisor with the Business Advisory Directorate at the Office of the Privacy Commissioner of Canada. He is joining us via video conference to walk participants through key privacy information that digital content creators need to know. After his presentation, we'll take questions from the audience. Those watching via live stream can submit their questions through video chat on YouTube or commenting on Facebook video. And without further ado, Jacob, I'll let you take it from here.
Thank you very much for the lovely introduction. Hi, everyone. Like I was so wonderfully introduced, my name is Jake LeBlanc, and I'm with the Office of the Privacy Commissioner of Canada. And I'm here to talk to you about privacy in mobile apps and games. Before I get into my short presentation, I'll just give you a little bit of background about myself. I started my career in the public service as an immigration officer out of Pearson Airport. I worked as an investigator for immigration for about 5 years, doing different types of files. I spent a couple of years after that working with our Indigenous communities in Northern Ontario and the Sudbury region. And after doing that for a couple of years, the Privacy Commissioner tapped me to come in as one of his senior investigators. So I worked as an investigator for the Commissioner for about a year and a half. And now I've transitioned into this role of business advisor. So now my job is to leverage that experience I gained as an investigator to help businesses understand how not to get investigated in the first place. So without further ado, I'll start my presentation here. All right, so I hope you can all see the cover screen there. So like I said at the beginning, we'll be talking about privacy in games and apps, and this is a short regulatory overview for businesses. So before we get right into the applicable law itself, just a quick overview of what our office does. Our mission is to protect and promote the privacy rights of individual Canadians. To do so, we oversee compliance with multiple pieces of legislation. One is the Privacy Act that governs how government departments treat your personal information. Another one is PIPEDA, that's the Personal Information Protection and Electronic Documents Act. That governs how businesses use personal information. And Canada's anti-spam legislation, also known as CASL, that is, it's an anti-spam law, so it tells businesses how they can and cannot conduct widespread marketing campaigns. Our office itself is divided into two parts. This is a new division that was just done at the start of the year. So we now have one side of our office that only does compliance. So they're made up of the investigators and their legal support teams. And then we have the promotion side, which is strictly for providing business advice to companies that operate in Canada and that collect, use, or disclose Canadians' personal information in the process. So PIPEDA is the main law that we're going to be focusing on today because, like I said, this is the act that governs what companies that use Canadians' data have to adhere to. The act is a principle-based act, which is significantly different than, say, the Immigration Act, which is based on a set of very prescribed laws. These principles are much more flexible and can be adapted depending on what sector or what business we're talking about. That said, all the principles apply to any business that uses personal information in the course of commercial activity. So you see the 10 of them listed there: accountability, identifying purposes, consent, limiting collection, disclosure, use, and retention, accuracy, safeguards, openness, individual access, and challenging compliance. Unfortunately, I don't have time to go through all of them with you today, but I've selected a few that, in my experience, are going to be the most valuable for you to know. And those are going to be consent, limiting collections, safeguards, and openness. In addition to that, I'd like to start with individual access just because we recently completed an internal review, a statistical review, showing what types of complaints were most commonly found to be legit, like well-founded complaints where businesses made a real violation of the law. And individual access was a big one that came up in that study. Individual access means that when you're designing your product or your service, you need to consider how to respond to a Canadian who requests access to their personal data that you're holding. This is a right of Canadians in the law. So they have a right not only to ask for that data, but to receive it within 30 days of the date of that request. So the reason that I'm finding a lot of these complaints to be well-founded is because companies aren't prepared for such a request. And because they're not prepared for such a request, they spend half of that 30-day time frame just figuring out what to do, and then often aren't able to actually respond within the 30-day time frame prescribed in the act. So the point here is that when you're developing your product or your service, keep in mind that someone is going to request access to their data, and you need to have a procedure in place to facilitate that access request. As another side note to that, you would also want to keep in mind people that may be disabled in some way because they retain that right to access. So simply saying, well, I'm going to write them a letter providing them with the information won't be enough to satisfy an access request that comes from, say, a blind person. The next thing I'd like to talk to you about for a little bit is meaningful consent in minors. Consent is probably the trickiest principle to apply in the entire act, and that's why I wanted to dedicate a bit of time talking to you about how consent works in 2018. It's challenging because the law itself was written in the early 2000s, and you guys are engaged in the digital marketplace and easily understand that technology has grown so rapidly since then that laws and regulations can struggle to keep up with the pace of change. Because of that struggle, what our commissioner does with our policy team is he releases updated guidance on how the act is to be interpreted, as opposed to trying to rewrite the law every couple of years as technology changes. So one of the big things we've done in this regard in the last year is publish updated guidelines on meaningful consent. If you were to go to our website at www.priv.gc.ca and type in meaningful consent into our search bar, you would get access to these updated guidelines, and they'd be very valuable for your business, regardless of whether or not you're in the startup stage or you're just about to launch or your product has existed for years, because this is an updated interpretation of how consent works in PIPEDA. What's important for us to know is that consent differs depending on the age of the person that you're trying to get consent from. So we know that it's unrealistic to expect children to fully appreciate the complexities and risks of sharing their personal information. This means that the Act needs to have some way to get consent from someone who's not a minor, because if the minor doesn't appreciate the risks of sharing their information, then consent really isn't meaningful in the first place. So anyone that your app is being used by who is under the threshold age of 13 will need to have demonstrable consent from their parent or guardian who is of age. Once you're dealing with minors who have reached the threshold age of 13, they can provide meaningful consent, but it's important for the business to take into account their level of maturity when developing the process by which that minor will give consent. So giving a 13, 14, 15, or 16-year-old legal privacy policy full of legalese that I can barely understand isn't going to be sufficient for the commissioner to determine that that minor actually gave consent for the company to use their personal information through the app. Those privacy policies, when you're dealing with minors, need to be simplified down into a language that they can reasonably be expected to understand. Two other things I'd like to talk quickly about before we move on consent. One of them, if we talked about the threshold age being 13, and they can give consent at that age if it's simple enough. But one of the things that I like to see that's happened is these just-in-time notifications. For example, when I use my Samsung phone to take a screenshot, it will ask me if I want to save that screenshot to the SIM card on the phone or if I'd like to upload it to the cloud. This is getting consent directly from me, and it gives me the option of what happens now with the information I'm uploading. The screenshot may not have had any of my personal information, or it may have been a selfie. So regardless of what the screenshot is, the developer has put in a consent control or a consent process that allows me just in time to say yes or no. So it's more than just signing a privacy policy. When I first got the phone, there's constant just-in-time notifications that occur while I'm using the device or while I'm using the app that allows me to provide consent over and over and over again instead of just a one-off when I start using the product. Next, we're going to talk about the ways you can protect personal information, either through being open or the safeguards that you use or limiting the collection of the data that your product or your app utilizes. So the openness principle is basically in a nutshell saying that someone somewhere is going to figure out how your app or product uses personal information. So it's best for that information to come directly from you. The investigative teams use all sorts of ways like reverse engineering or testing pits or interviews to figure out how apps work once a company is under investigation. So it really is in a business's best interest to be open with their consumers about how data is being used. Again, going back to our consent conversation, if your user base is extremely young, this openness principle would imply that the language that you use to be open with your customer base is something that they can genuinely understand. And again, this part here talks about those just-in-time notifications that I was speaking about. And that's part about being open too, because it's much clearer if the app is informing me what's happening with my data as I'm using it, as opposed to saying, well, Jacob signed the terms of service 3 years ago. The onus is on him to understand the legal complexities there and about how his data is being used every day. Safeguards is another very important way to protect the personal information that you collect and use in the course of doing business. The important thing to remember about safeguards is it's not a static requirement. What I mean by this is, let's say you launch a product and the only personal information you're collecting is someone's first name and their shoe size. So the sensitivity of that data is fairly low. So you would only need a lower level of safeguards to match the sensitivity of that data. But 3 years into the product, you decide you're now going to collect last names and addresses. So the sensitivity of the data you collect has gone up a bit. You would need to demonstrate that when you made that business change, you also changed the safeguards that you use to further protect that additionally more sensitive data. Again, if 3 years later you now decide you're going to collect credit card numbers, that's another increase in the sensitivity of the data you collect, and you would have to be able to show that you did another increase of your safeguards. Now, if you launch the product with super high safeguards already and the data is already low, you don't need to keep moving higher and higher. You just need to be able to show that the safeguards that you're using are adequate to protect the data based on the sensitivity of that data. The last one we'll talk about here today for protecting personal information is limiting collection. This is probably the most straightforward one that I've talked about so far because it's self-explanatory in and of itself. You must, by law, collect only the information that you need to operate your product. You cannot over-collect data because you may want to use it at some other point in the future. You need to limit the collection to only what you need. How that protects personal information is really in the scenario of a hack or a privacy breach. If you adhere to this principle of limiting collection and you are hacked, the hacker will only have access to the data that you needed, that small trove of data that was only required for you to run your product. If you were collecting a whole bunch of superfluous data in the background, well, you just gave that hacker a giant treasure trove of data that you never even needed to collect in the first place. So this is sort of a proactive protection of personal information, assuming that you're going to have a breach in the future. It's always best to limit that collection of personal information to only what you need. I've summarized one of our investigations here for you. It's called our VTech Investigation. The commissioner does not publish all of the investigations that we do, only those investigations where there was a significant lesson that businesses could learn, or that the impact on Canadians was significantly high, or that it was in the obvious public interest to disclose the details of the investigation. So this is one such case. If you want to read the entire report of findings, the entire decision, you can go on our website at www.priv.gc.ca, type in VTech, VTECH. You'll see everything that we published on this file. But this was an investigation a few years ago about a connected toy maker. So not quite an app, but the law applies very similar to someone who makes an app for children and someone who makes a toy for children. So an attacker or a hacker was able to exploit a well-known vulnerability in their computer network and was given access to things like names, dates of birth, voice recordings of children, and their pictures. The investigation concluded that it was the security shortcomings related to how they tested and maintained their system, their internal access controls, so those operational safeguards weren't there, their cryptography was weak, their monitoring of the system was weak. So had they had better safeguards, had their safeguards matched the level of sensitivity of the data that they had been collecting, it's very unlikely that the hacker in this case would have obtained the gigantic treasure trove of children's data that they were able to obtain. Now, to paint some bright light on this company, once the investigation launched, they did an excellent job of engaging with the OPC to figure out not only what to do in response to the breach to limit the damage that was done, but also how to prevent any such future breaches from occurring in the future. If cybersecurity and privacy hacking is something that is of significant interest to you, not only is this file available on our website, but a very famous investigation that we did into the Ashley Madison site is also available on www.priv.gc.ca. And you can learn again how the safeguards were inadequate to protect the highly sensitive data that company held on through their website and through their mobile app. Speaking of seeking help from the OPC, there are multiple ways that you can get assistance from us. If you have a basic question that you think could be answered in a sentence or two, give us a call. I've got an entire team that mans this 1-800 number, 1-800-282-1376. They are there every day, 9 to 5, ready to answer your questions. So if you're just about to go into a meeting or you just came out of a meeting and you want to ask a privacy expert a question, go ahead and give us a call. They're very good at answering your questions on the spot. If they need a little bit more time to deliberate and research your question, that's okay too. They'll get back to you in a day or so. I've mentioned our website as well a few times, www.priv.gc.ca. It is full of information about privacy laws in Canada. You can navigate the website a couple of ways. It's organized in different folders, so you can see investigations into businesses, investigations into government departments, the Fair Information Principles. All that's there for you. It also has a built-in search feature, which I always recommend. Just use the search bar in the top right corner, type whatever it is you want to learn about: protecting data, cloud computing, consent in minors, meaningful consent, inappropriate data practices. All of that is totally searchable on our website, and it'll bring up everything that you need to know about the topic of interest. You can also engage with us online. We're active on Twitter, YouTube, Facebook, and LinkedIn. And again, I have a team that their job is to monitor those channels on a daily basis, and they should be able to respond to you. If they don't, because they can get flooded sometimes, please consider calling the 1-800 number or accessing our website. I've saved the best for last. You can get specific advice from a business advisor like myself or a colleague on my team. You can email me or call me directly. My email is jacob.leblanc@priv.gc.ca. My phone number is 416-973-6955. The way this process works is I'm looking for anyone who has a specific product or a specific practice that they want specific advice about. So this isn't a channel to get general advice about how to comply with PIPEDA. This is for a specific app, product, or service that you're either in the concept phase of developing or has already reached market or just about to go to launch. It doesn't really matter what phase of the business you're at, as long as you have a specific product or service to talk about. What I would do in the scenario where you email me with such a request, I might get a little bit of extra information from you and then provide it to my director. And he's the one who decides which consultations we'll actually be able to accept and provide advice on based on our organizational capacity. So we've got about some extra time here. I'm glad I was able to move through that fairly quickly so that I can open the floor to questions and spend a bit of extra time engaging with you and figuring out what it is that I can do to help you out today. It's not too often that you get a privacy expert in front of you, so I'm glad that we got a little bit of extra time for this. Thanks for listening.
Hi, Jacob. Colin here. I have one question which it relates to this. We were talking about language in terms of minors. Does that also for adults as well? Because one question I've had for a long time, being in the video game industry and being in websites, et cetera, is when the language is legalese and the language can get long. I mean, Apple has terms, conditions, and privacy that verge on 100 pages, I think. Is that even meaningful? And what point does the Privacy Commission, does the POC say, look, that's just not acceptable? So you have to cover everything, but how do you cover everything and not make people nod off on page 55? Yes,
excellent question. It's hard for me to say what the Privacy Commissioner would say about a 100-page privacy policy. Honestly, the best place to get your answer to that is in our updated consent guidelines, because we talk about how the office is dissatisfied with some of these very long, very legalese consent policies, whether or not they're targeted, like you said, at adults or at minors. I'm very tempted to speculate that an investigation that goes into a 100-page privacy policy would likely result in it not be considered meaningful. But I can't, without seeing all the facts and without it being a particular investigation in front of me, I can't in all confidence say that a 100-page policy would by default be considered not meaningful. In terms of a solution for the companies, we're definitely looking for a simplification of these policies. I wouldn't mind, I can see why a big company like Apple would bristle a little bit, because their legal team is all about minimizing liability. So they want to be able to say, if we're dragged into court, I can point to page 56 and say, look, it's there, you signed on the dotted line, I'm covered. So if I was engaging with a company like Apple, I would say, look, if your lawyers want you to keep that 100-page privacy policy, keep it, but let's develop a shorter version, a synopsis, so that people can have a legitimate understanding of how their data is being collected and what it's being used for. And then if they're really into it, they can click on links in that synopsis policy and go into the actual full legal document and read that particular section. So this way you're guiding users to the pages in that super long policy that they're actually interested in. And overall, you're increasing their understanding of the policy itself. That's sort of the best answer I could give based on the question. But again, on our website, those updated consent guidelines are going to be the most valuable tool for Canadian businesses moving forward.
That's the correct answer. The best answer would have been to say, Apple, make it one page. But is there anybody?
I wish.
Is there anybody online or that wants to ask? George, did you have one?
Hi, thanks again for the presentation. It's George Gates from Battlegoat Studios. That was quite interesting. The question I have is probably doesn't have a very clear answer to it, but I'd like to know certainly what the office's opinion is on that, which is age verification. So when we're talking about the minors and under 13, certainly if you visit Instagram, you've never seen so many elementary school students who are 18 years old before. What's the stance on how forceful age verification should be? What's the requirement for it? Why is there such a ability to get away with not enforcing it when you are dealing with minors in particular?
Yep, great question. I was actually thinking about this today because I knew I was going to be talking about minors, and I was thinking, like, when you're 9 and you're signing up for Snapchat and you click the button that says, yes, I'm 18, how is the app developer supposed to know that you are actually 18? I've seen some products that collect ID. For example, Airbnb. In order to sign up for that service at a point in their business line, I'm not sure if it's still active today, you had to upload photographs of a government issued ID. My issue with that style of age verification is it ups the risk because the app developer is now collecting additional and potentially more sensitive information than they originally needed to. But there really is no. It's a tricky question. How do you verify someone's age digitally? I'm excited about some new products in terms of digital verification that are coming into play using tech like blockchain. So I'm hoping that as the digital economy matures, we have a better way to establish identity online, because it's a huge challenge right now. The last part of your question was the frustration about why is there a lack of enforcement? Because all of us can go on Snapchat and Instagram right now and identify individuals who are most certainly not of age to use the service. We at the office struggle with the lack of order-making powers. So we are able to make recommendations to companies at the conclusion of an investigation, but the commissioner does not have order-making powers. The order-making powers come from the federal court, and the commissioner or the Canadian who made the complaint now has the onus on them after the conclusion of the investigation to take the findings to federal court to have the company be put under order to make a change. So anyone who's engaged in the federal court system knows that this takes a very, very long time, and the level of engagement is not high enough to make this enforcement happen on a regular basis like it could if the commissioner had something like order-making powers, where at the conclusion of an investigation, the commissioner could order a company to make changes, to force them to do better age verification, to force them to separate their services for adults and minors. So it's tough to answer a question because we're struggling with age verification as a regulator all the time, in the same way that I'm sure that your app developers and your product makers are struggling.
Yeah, thank you. And I would add the one thing is, as a consumer, I certainly am concerned about age verification that I have to participate in. Like, for example, when I have to send Airbnb a copy of my driver's license that doesn't feel very good to me at all. I generally assume the information I share, especially with large multinational companies, is eventually going to be stolen or hacked. And so, having that information, lost, if all I share with them is my email address or maybe even my phone number, I'm not concerned. If I share my driver's license, I suddenly become very concerned. So as a consumer, sharing information that is not necessary for the operation of the organization, like Instagram, sharing information with them that for age verification that they don't need for other purposes would concern me. So I wouldn't like to see that overdone either. But thank you for that.
I tried to echo that concern in my answer. I feel the same way, sir.
Hello, my name is Shobita Ravindra, and I'm a lawyer out here in Hamilton, Ontario, interested in privacy law. Hello.
Awesome.
In terms of meaningful consent for people who are children above the age of 13, and you mentioned that you consider the maturity of the age. When you say, do you mean like maturity in terms of the person? Because, are we talking about the maturity considering, okay, what would we consider to be mature for somebody of, would be at the level for the person of that particular age? What is, could you be elaborate a bit more on maturity?
Sure. So maturity can be very tricky for a developer, because we can, as a regulator, assume that the level of maturity of a 13-year-old would be different than a 16-year-old, would be different than a 19-year-old. But anyone who works in a high school, say, will understand very quickly that it's not so cut and dry. You'll have a 19-year-old who is nowhere near as mature as a 13-year-old, and vice versa. Of course, this poses a problem to us as a regulator because it's hard for us to expect a company to know the mental maturity of every 13-year-old who's signing up to their app. So 13 was chosen as a threshold age below which no minor in Canada can provide meaningful consent. This was done, after consultations. It can be difficult to choose an age like that, but that is the number that the commissioner chose. So below 12, doesn't matter the level of maturity, they need to have consent from a parent or guardian. 13 and above, we say that the law does allow them to provide consent, but the company must take into consideration the level of maturity when designing those processes. The way that we understood this in our updated consent guidelines is that the company can make reasonable assumptions about the maturity of a person at that age. So this kind of leaves behind people that may not be as mature as their age. They would still be subject to processes that are more mature than their level of maturity. This is not something that you can absolve companies of completely, but it's not something that you can hold against them either. So I understand, from a legal background, how this kind of leaves a shade of gray in the enforcement of the law. Like, would an investigator in that scenario try to determine the level of maturity of a specific 13-year-old? Or would the investigator say, you know what, this company made reasonable policies based on what they could reasonably assume the level of maturity of a 13-year-old is? The key here, in my opinion, would be the reasonableness of the actions of the company. If the company can show that they took reasonable steps to make consent understandable to a person of that age, in my opinion, it would be difficult for an investigator to find a violation of PIPEDA based on those updated consent guidelines. But please give those guidelines a read, and hopefully they'll add some extra context to my answer that I wasn't able to provide.
Okay. And would we be able to get a copy of your presentation by any chance? Or?
Absolutely. If you can't get it directly from iON there, just send me an email. I know I had a slide there. It's jacob.leblanc@priv.gc.ca. I'd be happy to share it with you.
Okay, thank you.
My pleasure.
Okay, there is a question online. So if a company such as VTech collects videos and images, are they required to provide all of that content if requested to the end user within 30 days? And if so, how does that content get provided and who covers the expenses? Let's say 100 gigabytes of video data has been collected.
Yep, great question. So the answer to the first part is, do they have to provide all those images? And the answer is yes. The law is very clear that the company is holding personal information about the user. In that scenario, it's likely a picture of their face. Even if it's 100 gigabytes of video data of that individual's personal information, the company is required to provide that data within 30 days. The 30-day timeline is a prescription in the Act, but it is not immovable. The company can inform the requester that it's going to take longer. They simply need to tell the requester two things. They need to tell the requester that it's going to take longer and why. They also need to tell the requester that if they're not satisfied with that explanation, that they can file a complaint with the Privacy Commissioner. So in this particular example where we're dealing with 100 gigabytes, it might be reasonable to give that company 90 days. They could tell the person that made that access request, hey, it's going to take 90 days because it takes us, 30 days per 30 gigabytes or whatever. Therefore, it's going to be 90 days to totally download this and provide it to you. Then they would also have to tell that individual, if you're not satisfied, you may file a complaint with the Privacy Commissioner by visiting www.priv.gc.ca. That would cover them for the extension part of the scenario. The other part of that question was, how do they provide access to that? This can get a little bit tricky because the Act itself doesn't tell companies how access is to be provided. Generally speaking, what I've seen in my history is like the company will provide a written response. They'll be like, this is the data that I hold on you, or these are all the emails where your name is mentioned. For this particular scenario with VTech, you would expect that because the data they're holding is video, that it would be provided by video. That said, the act isn't prescriptive in that manner, but it still would have to be access to their data. So it would be very difficult, in my opinion, for VTech not to provide the data in video form. Like, it wouldn't really make sense for them. They have 100 gigabytes of my face as my digital image. For them to somehow provide that in writing would be weird. I'm not sure how that would work. Then the last part of the question was the cost. The cost must be handled by the company because it's an access right for the Canadian. It would not be fair for the Canadian to be burdened with that cost because it's a right. So people who are economically disadvantaged can't be disadvantaged from exercising a right. That being said, I have seen scenarios where a company says, okay, sir, I have, or sir, ma'am, I have 100 gigabytes of video data about you. I have an office a kilometer away from you or 2 kilometers away from you. We'll book an appointment for you to come in and view the data. And that's fine. If that person then also wanted, so they've been provided access to their data, right? They were able to go in, they were able to view the images, they got the access that they were required to receive under the law. If the person wants a copy of that data, so they're looking for additional services from the company, there it would seem reasonable that the company provide a surcharge because they've already given that person the right of access, and now the person is looking for additional service. So in that scenario, I could see where the burden of cost would be shifted to the person requesting access, but that's only because they've already been provided with a free form of access. Thank you for your question. Very good one.
So we are taking questions online. If anyone
Awesome.
has any questions, they can ask there. I'm just waiting to see if there's any more questions before we wrap up. So if you have
Wonderful.
any questions, now's the time. Great.
Hi, I actually have a question which I'm not 100% sure it's only privacy, but it certainly relates to that.
Okay.
If you are on, all of us are on social media, or if you run a website, you have a community that you're involved with. I personally ran a community for 12 years online. And during that time,
Awesome.
you run into every scenario under the sun. And there's two that are really challenging along these lines. And they both relate to the same point of people not being able to, mental health, number one. And when you contact, can you or should you contact people that are friends or family or whatever when you see someone's in danger? Is there a privacy concern there? And of course there is. So how do you address that from a privacy point of view? So looking for a little guidance there, because there is no perfect answer. We know that, but there's a privacy side to it. And number two, there's mental health in terms of depression, anxiety, etc. There's also mental health in terms of people that have been your customers for a long time, and they're clearly starting to struggle with cognition themselves. They're doing actions that they don't remember, etc. Do you contact their family? Are you allowed to contact their family and tell them what's going on?
That's very tricky. So
good luck giving a good answer on this one.
In a scenario where, like, you're, as a business, you're noticing a cognitive decline in the ability of an individual, it doesn't give the company the right to contact external parties unless the individual has given consent to that. So, like, I understand your concern, and I feel it in your question, because you want to do the right thing, but often you're constricted by things like the government's constricted by the Privacy Act in these areas all the time, and businesses are constricted by consent under PIPEDA. I think the best thing to do in a scenario like that is to, if you know that this is going to be an issue, you should build in processes that people can consent to in case this occurs. So when I'm signing up for the bank, I can say, hey, look, if I become emotionally or intellectually incapable of engaging with you, you may engage with this individual, my parent, my spouse. It's not the same as a power of attorney, but at least it would give the company some out to say, look, I noticed $10,000 missing from her account. She couldn't understand it, but she did consent for me to provide limited financial information to a loved one. and therefore I'm contacting you with this information. I can see that we're working under the law as long as consent has been obtained and it's very clear what data is going to be shared under what scenarios. But yeah, very, very tricky question, sir. And I think that would be a good one for a larger privacy conference where more expertise could kind of weigh in, because I'm not a mental health expert. I don't know exactly what sector that would relate to, and it would be different if we're talking about someone's bank account or if we're talking about someone's account with, Tom's shoes.
Sure. So just to clarify, actually, I was not exactly clear when I was asking, but there was two parts to the question. So one was someone's declining cognitive capabilities related to age in general, but not always. But there's also the case where there's spikes of anxiety or depression, and you literally are worried about their health at that point, their safety. And, does that change privacy in the slightest as well?
Like, I wish it would. If there was something that you're like, I can save this person's life, I would hope that there was something that you could do to do so. But as a business, you've got to be careful not to overstep your bounds.
Yeah.
If there's no commercial activity involved, if this is an online community and you're not running a business, then PIPEDA doesn't apply at all. It only applies when personal information is collected, used, or disclosed in the course of commercial activity, in the course of making money. And when you're in that business relationship, I hear that I want to be empathetic with the business owner who wants to help save someone's life, but they've collected personal information in the course of doing business. They have to comply with the privacy laws that are at play, and that's why in my answer I was trying to work within the existing law to say how could a business that encounters that still act as a good corporate citizen while at the same time complying with the law.
I appreciate that, and thank you very much for your input.
My pleasure.
Actually, someone online had an additional question related to that, where they asked if the communities are public, would contacting the third party still be an issue?
If by public you mean that it's not a business, right? Like if we're like, let's use an old school one like ICQ, right? If I'm talking to my friend on ICQ and they're talking about self-harm, then yeah, I can call the police, I can call the parents, I can do whatever I want as an individual citizen. Would ICQ be able to use an algorithm to detect that phrase and then automatically contact the police? I don't believe so, unless, like I said, they had in their consent policies that that's what they were going to do. They made it very clear to users, like, hey, I've got a robot monitoring your chat, and if you start talking about terrorism or self-harm, this is what I'm going to do. It would have to be clear to the users that that was part of the agreement when they sign up for the service. So the fact that it's public doesn't really matter. It's whether or not it's a business we're talking about, or are we talking about just the users of that service? Because it's very, very different when we're talking about, in my example, ICQ making the disclosure to the police, or if it's the person's friend they were using the service to talk to.
Okay, so I guess in a continuation of that, what if it's an employee of ICQ who, outside of a policy decision, is like, oh, I'm worried about this person, I'm going to, as a citizen, even though I'm employed by this company, could they do that, or is that a concern for privacy?
That would certainly be a concern for privacy, because they're a part of the body. They're an employee of ICQ, and ICQ is the one who collected data for commercial purposes. So because they're an employee, they're considered an arm of the company, and they're restricted by in this case, PIPEDA.
All right, there was another question going back to the VTech, further to that discussion. The person asked, who is responsible for scrubbing the data to provide the personal data? So let's say there's 1,000 videos in that 100 gigabytes, but only 3 of those clips are personal.
Yep. So at the end of the day, it's VTech. It's the company who's responsible. Whether they have a dedicated team, they may delegate that to IT. They may delegate that to someone in their privacy office. At the end of the day, it's up to them as a company to make sure that not only can they provide access to the data, but that they don't provide, in doing so, that they don't provide someone else's data, that they don't commit a privacy breach while fulfilling an access request. So it's the responsibility of the company to figure out how it is that they're going to deal with these access requests and how it is that they're going to, like you said, scrub or scan that data to make sure that they don't make additional unlawful disclosures while providing that Canadian with their right of access to their personal information. But it really is up to the company.
All right. If anyone else has any questions online, this is your last chance. Otherwise, we will be wrapping up. So I'll just give it another 10 seconds to see if anyone has any last minute questions.
Sure.
Okay. It looks like we are about done. So.
Thanks, everyone.
All right. So thank you so much, Jacob, for the informative presentation. We appreciate you taking the time to speak with us today. Before we leave, I'd like to say thank you once again to our presenting partner, the Canada Media Fund, our event partner, RBC, and our community partners, McMaster Innovation Park and Hamilton Economic Development. And thank you, everyone, for coming again.